That's very exciting. All right, well, welcome back to the non-round areas, the mini round areas. And we're going to have our first panel conversation where we're going to kind of set groundwork on the current mechanisms, and Bill, Tracy, and Paulina, Jenney are going to present to us on intellectual property, like a 101, to ground us all in some of the traditional current mechanisms, and then also the U.S. patent and trademark process. Yeah, I'll leave it there. And so we're going to have about an hour together for this panel. Bill and Paulina are going to present for about 40 minutes, and then we're going to have question and answer after at the end. I also want to just let folks know that we are webinar broadcasting. Hi, everyone online. Welcome. We're webinar broadcasting this. And so at any point, any questions and things like that, we're wanting to talk into the mic. So everybody can be part of the conversation online as well. And we're going to be taking questions from the chat. Thank you, Ms. Nix, for running that for us. And there's 2 microphone stands, one on either side of the room. So at the end, when we do Q&A, I'm going to invite you all to line up and queue at those mics, and we'll do Q&A in that way. So we're joined this morning by Bill Tracy, who is a professor of plant and agroecosystem sciences at the University of Wisconsin-Madison. Bill is a sweet corn breeder and studies genetics, biochemistry, and physiology of sweet corn quality and productivity. And Paulina Jenney, who is an outreach specialist with the University of Wisconsin Extension. And Paulina supports the USDA's Farmer Seed Liaison Initiative in her position there, and is the co-author of their 2023 report, More and Better Choices for Farmers, Promoting Fair Competition and Innovation in Seeds and Other Agricultural Inputs. So welcome, Bill and Paulina. Take it away.
Thank you, and thank you all for being here. I hope you had a good morning. Yeah, I'm going to start off with a few remarks and then get to I hope, a short enough slide set. So the first thing I want to talk about is why I think this is important. And of course, IP lies at the root of this, what I'm going to talk about. And it's really the consolidation of the seed industry. And we know a lot about that from the level of economics. It's been well documented how extreme it is in terms of competitiveness. But I'm not sure we really thought so much. Some people have, certainly, some people in this room. But we really thought so much about, excuse me, the biological issues involved. So when we talk about the consolidation of the seed industry, we really should be talking about the consolidation of the pesticide industry. Basically, what's happened is essentially all the major seed companies have been subsumed by pesticide companies. And of course, when that's happened, then farmers are offered a combination of both a new variety that you have to use a pesticide for. Of course, many of you know about this. So basically, seed, the foundation of the world food production, is now controlled by 3 or 4 international companies, only one of which is based in the US. So what follows, I want to give a little context, a little perspective, my perspective. So over the last 150 years, 175 years, the landscape of plant breeding has changed nearly completely. The changes can be represented by a number of trends. From a time when all farmers essentially did breeding to some extent, to nearly all professional breeders. This is at least in the northern world. When there were millions, literally millions of breeders around the world to now a few thousand. When all breeding was for highly localized adaptation, creating all sorts of diversity, now we look for some of the major seed companies, I'm largely talking about corn here, as highly broad adaptation. resulting in a landscape of uniformity. When crops were bred in every environment in which the crop would be successful, today breeding is really, again, for this wide adaptation and leaving off smaller markets and smaller areas. This leaves behind underserved growers. Well, I've talked for years about it, the abandonment of the margins, where the seed company is actually, we don't do that part of the seed company, the corn belt, or we don't do that part of the acreage. The margins, if you look at a map of productivity and increasing productivity for corn, for example, you'll see that it's the heart of the corn belt where yields have improved. All around the margins, there's been no improvement. And this leaves those farmers at a deficit. So I'll move on from that now, but we can look at maize in North America to see these trends. Roughly 9,000 years ago, people in South Central Mexico began the process of domesticating maize. The people bred it for highly localized adaptation and uses, resulting in Mexico alone, many thousands of local or farmer varieties, that were adapted to diverse environments from Canada to Chile. When the Europeans began colonizing what is now the eastern United States, they found native people cultivating just two, but the two types were very diverse, the northern flint corns and the southern dent corns. And each type had hundreds of locally adapted varieties. The colonizers began growing maize, and they too, like all farmers at the time, began breeding for improved to their needs. When the colonizers moved into the rich savannas and prairies in the Ohio and Mississippi River valleys, every farmer was still working on developing varieties for their own farm. However, things really started to change during the second half of the 19th century. The Hatch Act, many of you may not even know what that means, but it created state experiment stations where they were doing research. And these state experiment stations, one of the favorite things they loved to do was develop new varieties. So we're starting to see the concentration of plant breeding in the hands of experts. Many of the new programs were designed to support on-farm breeding programs, what we now call participatory programs. But there's a number of examples where they were doing participatory research at the turn of the century, last century. At this time, some farmers began specializing in seed production and breeding, which resulted in fewer farmers saving their own seed. In the 1930s, and this, of course, as many of you know, was a big change, hybrid corn began to be widely planted across the Corn Belt, thus beginning the modern seed company and beginning the end to 10,000 years of American farmers breeding corn and saving seed. The seed companies initially depended on inbreds that were developed at the state experiment station. And there was a proliferation of what we call mom and pop seed companies. Over time, the private seed corn sector expanded. And by the 1980s, most land-grant universities were no longer developing inbreds, and the large companies had subsumed all the smaller companies. In 2025, the trend of seed company consolidation has essentially reached an endpoint, with just 3 or 4 significant private sector companies. And what most people don't know is that actually they collaborate a lot. People think Bayer and Corteva are mortal enemies. Well, they work together. So we're really down to a very few people making decisions. So as I said, after 10,000 years, we've gone from a point where millions of people each year were making breeding decisions and creating almost unimaginable amounts of local adaptation. Picture every valley in Mexico, in the Mexican Sierras, having numerous different varieties adapted to different altitudes and different tastes. Now, on the other hand, we have 95 million acres in the Corn Belt that are grown to one type of corn. And that group, the Corn Belt dense, what are being grown on the farms is an ever narrowing gene pool. So we have 2 to 3 companies breeding for the widest possible adaptation and making all decisions about the future of American food supply, and thus essentially American agriculture. The company's intense investment on corn in effect dooms many other crops to minor status. Extreme consolidation has resulted in marketing and concentration of the largest, most valuable markets, and as I said before, abandonment of the margins. Likewise, and of course this ends up hurting underserved people most, likewise, companies have abandoned hundreds of less lucrative crops, both less lucrative varieties of various crops, but also they don't sell many crops anymore. And how many people in this room have heard growers complaining that their favorite variety is gone, that it's lost? Unsurprisingly, this abandonment, if you will, excuse me, results in underserved people, damage to underserved communities more proportionally than the Corn Belt, for example. So with that, you've got me up there. So humans can own life. That's the question. And of course, we all know the answer now, but for many years, that was not, the fact that they can own life was not something that most people thought was true. Historically, seeds were considered the common heritage of humankind. And a quote from one of these articles: no person can, well, the quote, no person can exclude other persons from its use. And more importantly, people often shared their varieties with other people. When a village or a farm lost its varieties, people would share the varieties. No. So now it's not a question anymore, it's an exclamation point. Humans can own life. And there are a number of steps to this. And one of the ones that has become involved, and I'll talk about this soon, but the Convention on Biological Diversity that happened in 92, 93. And what that convention did was recognize that the northern countries, the global north, they were already owning life. And this Convention on Biological Diversity was created so that people of the global south actually had some say in that. And then another thing that I'm going to talk about in a minute, the FAO Treaty on Plant Genetic Resources for Food and Agriculture was signed in 2016. The line that you see on the bottom there, Standard Material Transfer Agreement. I'm going to talk about that, and to me, it's an insidious role in seed saving. So what is intellectual property? Of course, creations of the mind from the World Intellectual Property Organization, such as inventions, literary and artistic works, design and symbol uses, images. It's the protection of intellectual property, intended to protect and reward inventors, recover investment and generate income. And so this is actually in, well, not these words, but in the US Constitution, the right to apply for patents is given. You'll notice that in the US Constitution, there are almost no other rights. There are no rights for people, except until we get to the Bill of Rights. But the founders actually were very concerned about patents and not so much about people. Just some milestones. In 1930, the U.S. Plant Patent Act, and it's plant patent. We'll get into some of these terms a bit. Only clonally propagated crops were included under that, and one major clonally propagated crop that was not used there was a potato, and they left the potato out, of course, because it fed many poor people, and also, because the clonal propagule is the potato. So that was left out at the time. I like to think of this as the Luther Burbank rule. Luther Burbank, as some of you know, many of you have forgotten, Luther Burbank was an extremely productive breeder and developed many, many varieties. And he had powerful friends who knew him, like people like Thomas Edison and Henry Ford. And they pushed through this act, recognizing the value of crops. Luther Burbank, I don't think ever was able to profit from that. I think he passed away before the law became effect. Then we have plant breeders' rights, so-called PVP. That's the abbreviation we use there. In Europe, Europe and most of the rest of the world, it's called UPOV. And then I would say I was around then, just getting into the plant breeding world. And most academic plant breeders actually were very unhappy with this. But it was recognized with this next step, which is in 1973, getting way ahead of myself. Basically, when crops were allowed to be patented, utility patented, that's when many, many breeders became upset. But again, in the 1970s, a lot of the folks I know, older generation than me, were very upset, even that we had to have PVP for varieties. And the reason was really, well, the reason we had to have it is because the states started underfunding or not funding plant breeding at the state level anymore. So I'm not going to go through this table. The differences are pretty well known, and I want to. Are people going to get this slide set? Or, yeah. Okay. Good. What I want to talk about is a couple of things that are a little bit unusual. So the positives of a sample of the new variety have to be made both if you apply for PVP, plant variety protection, and a sample has to be deposited if you get a utility patent. And there's a lot of confusion about this. So you see something that is PVP'd and you want to get it, but you might, or actually more likely a utility patent, you want to get that thing that's utility patented, and you go to the National Plant Germplasm System and they don't have it. So if the PVP, the deposit has to go to the National Laboratory for Genetic Resources Preservation. And this, after 20 years, the material is made available to everyone. And if you're going through the National Plant Germplasm System at no cost. And on the other hand, plant utility patents, they also do have to make a deposit, and they make the deposit at the American Type Culture Collection. Now, there's a big difference here in terms of availability of germplasm. The National Laboratory for Genetic Resources originally was mainly for plants. It's now for all genetic resources, was created to support plant breeding and safely store material. So you can go there now and get something. Well, I grew some corn this past winter. 1957 came from there. Last time it was increased, and it grew beautifully. On the other hand, the American Type Culture Collection was started to store fungi, penicillin, all of the original strains of penicillin, things like that are there. And they don't maintain the crop. They get the sample, they put it on a shelf, and when you request it 20 years later, it's probably dead. So there's a big difference between utility patent. The other thing I want to stress here is licensing and contracting. Most of those PVPs, utility patents, those kind of things, they come with a contract. The license or the PVP itself does not restrict things too much. It actually says that you can use it for breeding or in research. But then it all depends on what the license says. And actually, I've actually never officially released any PVP or utility patent. I have actually, all of my stuff that's actually gone out economically is with a license. And we can talk about the details of that. But the license is where you can say, you can only do this with this product. A license can actually be opening. The license, my license says, when I put out a variety, that if you make an F1 between my variety and your variety, you can self out of that. And as long as you self out of the F1, I don't even need to know. The last thing, and I'm going to run out of time here, is I wanted to briefly talk about the standard material transfer agreement, because this is something that was started in the Plant Genetic Resources for Food and Agriculture. Its aim is to conserve and to sustainable use of plant germplasm and germplasm access and exchange via the SMTA. It's the SMTA that's tricky. I'm in favor of all of the values there, but it was developed from the this Plant Resources and Food Act. It's legally binding, and it must accompany each transfer of material. And I'm going to skip over this because I'm short of time, but the obligations when you get seed, well, I'm going to make one point back here. So if you get seed from the National Plant Germplasm System, and it's was put in the system after 1992 or 93, you will get this box. And when you get the seed and open the package, you've signed the agreement, you've signed the contract. And the key thing here is, if you commercialize a product that incorporates the material provided for further research and breeding, then normally you have to pay a fixed percentage of your sales of the commercialized product to a governing body. It's pretty vague. No one really, well, you have to figure out where the governing body is or what it is. So my last few slides are about the World Trade Organization. And most companies, for whatever reason, want to be part of the World Trade, most countries. And when you actually, if you're a developing country and you want to be part of the organization, you have to go by the so-called TRIPS rules. And one of the rules is you must have a patent system in your country. Another rule is you must have a plant variety protection system in your country. And for a lot of countries, this has been onerous and chaotic. So one last thing we're going to have time here for is, so Kat McCluskey and I were at a conference, Liberate Diversity in France, and we saw, this was a woman from Syria giving a talk, and in her talk, she discussed what happened to all the Iraqi seeds after the U.S. government took out Saddam Hussein and moved into the government there. Basically, and you'll be able to get a copy of this. I'm not going to read it because I'm out of time. But basically, it says that because the American conquerors basically thought it was so important to uplift the Iraqi people that they had to improve the patent law. They were actually still chasing down Saddam Hussein at this point, but they had to immediately change the patent law. And that's because, let's see, recognizing the last paragraph there, recognizing that companies, lenders, and entrepreneurs require a fair and efficient and predictable environmental for protection of their intellectual property. That's what was on the mind of the Americans at that point. I have a few other slides, but I'm going to stop there, and we'll take some questions in a minute.
Hi, everyone. My name is Paulina Jenney. As Kat said, I'm an outreach specialist at the Division of Extension with the University of Wisconsin-Madison. And I work mostly on the USDA Farmer Seed Liaison Initiative, which is a cooperative agreement between the UW-Madison and the U.S. Department of Agriculture. And one of the things we do is help seed growers navigate the complexities of the intellectual property system. So we've put together a number of resources on IP as it pertains to seeds specifically. And for the past couple of years, we've been working on this interagency working group between the Department of Agriculture and the Patent and Trademark Office to really talk about issues that affect seed growers when it comes to intellectual property. So today I am going to talk about the patent examination process, like what actually happens when someone is applying for a patent on a seed-related invention. So I'm going to talk about how to find information on seed-related patents. I'm going to identify opportunities for the public to participate, and then explain how to find the patent-related seed deposits that Bill was talking about. And I know that in this room, there are people who have like really strong positions on IP and seed. So I just want to be clear that I'm not here to advocate at all for any system of IP on seeds, but really my goal is to help clarify the process because it can be really, really complex and really opaque, especially for people who don't apply for patents and for people who aren't intellectual property attorneys. So if you have questions or want me to slow down or anything like that, like please feel free to just stop me and we can go through things a little bit slower. So the US is one of the only countries in the world that allows for patents on plant varieties. So as Bill was saying, most systems use plant variety protection, which importantly allows for research and breeding with the plant variety, while the utility patent system is a lot more restrictive and doesn't allow the public to use those seeds while they're under protection. And all utility patent applications are subject to the exact same requirements, whether you're applying for a patent on a car or a computer or a plant variety. And so all innovations have to be first determined eligible. So things that are eligible for patents are processes, machines, manufacturers, or compositions of matter. Things that are not patent eligible are natural phenomena, gene sequences, and ideas. So things that occur in nature are not eligible for patents. They have to be novel, so that means they can never have been described anywhere else. It has to be called what's considered non-obvious. So the difference between what already exists and this new invention can't be like something obvious to people who work in that technology. And it has to be considered enabled. So that means that it's described in such a way that a person of skill in the art, so that would be all of you, people who work with seeds, could make and use the invention based on what's in the application. And similarly, all patent applications follow a very standardized format. So there's always at the beginning of the application an abstract, which is just a short paragraph that summarizes what the invention is about. There's a background or summary section that explains the importance of the invention. It defines key terms, summarizes the claims, and sometimes it also includes what's called admissions of prior art. So this is where the applicant says something like, I know part of this invention has already been described, and here's where you can find that literature, but here's how my invention is different. And then there's a detailed description of the invention. So this describes how it was made such that a person of skill in the art can make and use it. And then finally, and the most important part of a patent application are the claims. So sometimes these are set aside in like a little separate section. It's always a numbered list at the very end of the application. So while a patent can be like 50 or 5 pages long and could describe like the entire universe of plant breeding and everything we know about it, the only thing that's actually legally defensible is this numbered list, this claim section at the end. And in the initial application phase, these claims are usually as broad as possible. People who apply for patents are usually trying to protect space in the market. And so they're sort of incentivized to try to get as much coverage as they can for any particular patent application. So they will write their claims to be as broad as possible, and then it's the job of the Patent and Trademark Office to then narrow them down to what's actually eligible. And importantly, because someone can put whatever they want in a patent application, it's good to remember that those claims are not actually defensible until the patent is granted. So a number of years ago, there was a seed company that listed a bunch of pending patents as, sort of, and claimed those as theirs. But yeah, the patents are not defensible until they've actually been granted by the Patent Office. So when a patent has been submitted, the first thing the PTO does is they classify it. So they read through the application and they assign it what's called a CPC code for Cooperative Patent Classification System. And this sort of tells the Patent Office what the patent is about so that it can get sent to an examiner who's an expert in that field. So for us, the code of interest is A01H6, and that refers to new angiosperms and non-transgenic methods for obtaining them. And all patents that are classified as A01H6 get sent to Art Unit 1660, which is a group of examiners who only look at patents that have to do with asexually reproduced plant varieties, plant cultivars, and transgenic plants. And that's a group of about 30 examiners, and most of them have higher education in the field of plant breeding. So they might have masters or PhDs in like genetics, plant biology, plant breeding, et cetera. So then as soon as they've been classified, the patent applications get posted on this very clunky government website. I've put the URL here for people who are following along online or want to visit it later. But I did this like quick example search so that y'all could see it. So you'll see I put A01H6 in the search bar there. I selected USPGPub, which is the database for pending patents. The next one, USPAT, is granted patents. And it returns this list of all the pending patent applications that are in the database. So here we're looking at an application for a hybrid tomato. So after the patent has been classified and published, then the examiner starts going through what's called a prior art search. So this is where they're reading through the patent application and they're trying to find any evidence they can that what is in this application has already been published or described elsewhere. So prior art is, any printed publication that indicates the claim has already been described. And this can be anything. So it could be previous like patent applications, could be variety registrations, it could be like scientific descriptions, it could be seed catalogs or even sales receipts. So the universe of what could be considered prior art, especially when it comes to plant inventions, is very, very large, infinite, you might say. And people have asked us whether there's like a set list of places that examiners always look for prior art, and the answer is no, unfortunately. Examiners always design their searches on a case-by-case basis. So they read the claims and then decide where they're going to look for prior art. And Emily in our next section is going to talk more about defensive publication and how to get descriptions of varieties in a place where examiners can see them. Because this search can be quite onerous and extensive, there's a resource called the Science and Technical Information Center, which is like a core of people who just help examiners do prior art searches. Often examiners have a very large docket of applications they're looking at, so they have a super limited amount of time that they can spend on any particular search. There's also an opportunity for the public to participate, to submit third-party prior art. And like I said, Emily is going to be talking a bit about this later. But what I wanted to just point out is that there's a narrow window during which the public, if they are aware of a pending patent application, can actually submit information to the examiner that the examiner has to certify they've looked at. And this is open from the moment it's published to at least 6 months after the publication and before the examiner has responded for the first time. And all that's needed to submit third-party prior art is the number of the patent application, a list of relevant references, and a short explanation of their relevance. So if you saw a pending patent application for like a broccoli with a particularly long stem, and you know, were aware of a variety that had those characteristics and say had like a seed catalog that described it, then you could like send the page of that seed catalog into the patent office and just say like, here's the patent I'm talking about, here's a relevant reference, and it relates to the first claim in this application. So they're really only looking for like 1 or 2 sentences. It's a pretty short form, and it's free for the first submission to any patent application. This is like it's not a very commonly used tool, so it's very unlikely that you would be the second submission to any patent application. But if that is the case, then I think it's like $90 for small entities. Okay, so after the patent examiner has put together their search, then they initiate the process of what's called patent prosecution. So this is a sort of like back and forth exchange between the patent examiner and the patent applicant, during which they try to come to agreement on what claims are actually patent eligible. So the examiner will go through their prior art search, and almost always they'll first issue a rejection because patent applicants always make their claims really broad. They're usually rejected at first on the basis of one of those qualifications. So they'll say it's not eligible, they'll say it's not novel, maybe it's obvious, or it's not adequately described. And especially for plant varieties, which have to be described in such a way that they can be made and used, this usually means they have to make a seed deposit. So as we all know, you can't like make a seed based on reading some instructions. You usually need to have access to the parents or access to the variety itself. So the examiner will require this seed deposit, and then the applicant will amend their claims to try to meet what the examiner is asking for. So they'll narrow the scope, they'll add details, maybe they'll make the deposit, and then the process starts over again, until either the examiner has decided that the claims are eligible and they grant the patent, or the applicant says this is a lost cause and abandons it. So all of that correspondence is also publicly available. So this is really tiny, but this is like an example of a patent prosecution case for a variety of corn. So you can see there at the bottom, there's like the list of references cited by the examiner. There's that initial non-final rejection. You can see where the applicant deposited their seed, amended their claims, and then a little bit later, the examiner finally issued the patent. And all of this information is publicly available. So if you want to look at the correspondence between the applicant and the examiner, you can do that. Let's see. Okay, and the last thing I wanted to talk about are the seed deposits. Bill kind of touched on this earlier. But especially for plant varieties, applicants are usually required to make a seed deposit, and that seed legally has to be made available to the public as soon as the patent is issued. And there's a little bit of a gray area about what can be done with the seeds before the patent expires. And this is something that we talked about with the working group between USDA and the Patent and Trademark Office. And they recently published a letter to USDA that said that activities that are done to understand the scope of the claims are permissible. And what they mean by that is that the information you can gather from the seed has to be the same as the information that you would otherwise get from a written description. So if you need to genotype the seed or plant it and grow it out to understand what the patent is actually claiming, then that's okay. But of course, like the patent holder is able to restrict the public from making and using the invention until after it's expired. So anything done with a commercial intent may be an infringement case. And all of those seeds get deposited to what's called an international depository authority. The IDA system means that one deposit is good for all jurisdictions across the globe. So if an applicant in China, for example, wanted to apply for a US patent, they could put their seed in the depository in China, and that would be good enough for the Patent and Trademark Office. But a sort of interesting thing about the IDAs is they're beholden to this treaty called the Budapest Treaty. And a part of this treaty says that IDAs can't give information about whether an organism has been deposited. So you might go to like the ATCC, the American Type Culture Collection, and see that, you know, they have cells for sale, they have microbes for sale, they have algae samples, but there are no seeds. And that's probably because of this secrecy clause that says they can't actually tell you they have them. Instead, the requester has to obtain the accession number from the patent itself. So if you're looking at a patent, this one is for a garden bean variety. We can see that in claim 1, it's been deposited under NCIMB accession number 44004. So then you would go to the National Center for Industrial Food and Marine Bacteria, and you would tell them I'm looking for accession number 44004, and then they could tell you that they had it. So the requirements for getting those seeds differ depending on the depository where it is. So sometimes they might send you a couple of forms you have to fill out, and it usually costs a couple $100s per accession. So it's certainly not inexpensive, which is something that we've also sort of been talking about with the Patent and Trademark Office. So in review, the points I really want to underscore is that only issued patents are enforceable. So anyone can say whatever they want in a patent application, but they can't enforce it until the patent has been granted. There is an opportunity for the public to submit third-party prior art. Of course, I know that would mean like monitoring the pending patent application docket, which would be time-consuming for anyone, especially people who are busy doing other important work, but that opportunity is there. And then finally, the public has a right to these deposits, but you have to be able to locate them. So the system is, in short, very complicated. But if there are any questions or people need assistance navigating it, that's kind of what the Farmer Seed Liaison was set up to do. Personally, I really like emissions. I love looking for patent applications and things like that. So I put our website here, still active as of this morning, I checked. And also my personal email. So if you have any questions, I really like talking about this stuff and would be happy to. So with that, I think we'll open it up to questions. Are you going to come on? Okay.
Well, thanks, Paulina. This mic is not for people my height. Okay, we are going to have a question and answer round now. And Shanda is going to be on this mic. Okay, so again, as a reminder, just go ahead and make queue in the line. Marissa over there with the computer is going to be bringing us in some questions from online folks too. And just be sure, Bill and Paulina as well, that you're using the mics. So Brian, go ahead.
Thank you. I have a two-part question. Actually, a third question came up, but I'll save it for later. First question is, once a patent is issued, what are the mechanisms for enforcement, and how is that carried out? And follow-up to that is, when conflicting claims are granted in patents that are issued, how are those conflicts resolved?
Sure. So your first question was when patents are granted, how are they enforced? And a lot of times, as Bill was talking about, those patents are enforced through licensing contracts or technology use agreements. So the company that's selling the seed will have the purchaser sign an agreement that says they won't violate their IP rights. Yeah, I think we probably see the most amount of enforcement on like, sure. We see there probably the most enforcement on seeds that have genetically engineered technology in them. seed companies that have patents have mostly said that they're not trying to enforce them against like smaller scale folks. But of course, they can enforce them how they will. And then your second question was when there are conflicting claims, how are they resolved? And that's always challenged in court. So either somebody who's been accused of infringing would have to take the case to court, or someone who sees issue with the claims can take them to what's called a patent trials and appeal board and say they think that the claims are conflicting and should be invalidated. Yeah, so those are the two avenues. Do you have anything to add?
Thanks, Paulina. Yeah, we're going to go back and forth. I just want to uplift like the point that you made about that the patent infringement is always handled in court, because oftentimes the argument is made like, well, but it's fair because anybody can take out a patent, like any independent breeder or small breeder can take out a patent, no problem. It's an even playing field. But of course, in order for the patent to be usable, you have to continue to defend it. And so it's an ongoing defense and financial requirement, right? Just want to add that a little bit. Okay,
Thanks,
great.
Kat.
Thank you. I have a two-part question. First, if you could speak generally to the historical precedent around novelty and non-obviousness within utility patents and classically bred varieties. And then also more specifically around the notion of prior art. You said that there's there's not one singular or compendium of databases where people are searching out prior art, but if we're talking about classically bred varieties with heritable traits, how you circumvent minimal or no prior art in the existence of granting a utility patent for a classically bred variety.
Yeah, so the patent office uses what's called like the Manual of Patent Examination Procedure, and that guides all their decisions when they're deciding how to how to make a decision about whether or not the invention is novel or non-obvious. And that manual is always updated in reference to like court precedent. And so it really is an open question about how a classically bred variety could be, considered novel and non-obvious if, plant breeders have been combining varieties for 10,000 years, like that, whether or not that is an obvious step is kind of an open question, and hasn't been challenged in court as far as I'm aware. And so in order to really like set that line, there would have to be a court case that would establish that the method of crossing two already described varieties is obvious. Would have to be decided in court.
Yeah, and I'd just like to follow up. One of Paulina's early slides basically listed a group of things it has to be, and any plant breeder in the room would say, no, that's not right. I knew we had to breed for yield. It's not non-obvious. But that's where we are now with plant utility patents. I will say also that Europe, well, most of the world, because many of the other countries in the world have adopted UPOV, and UPOV says you cannot do a utility patent. We're actually outstanding in that area, not in a good way.
Yeah, did that answer your question?
Hey, thank you both so much for your presentations. I'm learning a lot as a quite young farmer myself. I also have a question sort of in the prior art realm, and I'm specifically thinking about maize. Anthropology the record wasn't named in the list of things that examiners might go through. So I'm curious if either of you have had any experience where prior art is described through the anthropological record or ethnobotanical sort of record to block patents for indigenous varieties.
Yeah, I don't have an example of anthropological data, but there's a number of times when in maize but other crops as well, But this is not what you're asking, but there's other times when it's clearly, somebody can come along and say, hey, I've been doing exactly that for 20 years. But it's not the kind of data that you're asking about. And I would also say that the data, a lot of the data you're asking about, or potential sources, a lot of it doesn't exist. I've been on the maize crop germplasm committee for a long time, and a lot of times we discuss the idea that we should be taking more ethnological data, anthropological data on the uses of these crops, but we don't have that.
I can show you some.
Great. No, the USDA doesn't have it. So, but yeah, I'd be happy to talk to you.
Yeah, I would add that so naturally occurring phenomena is not patent eligible. So things that are found, already existing in nature can't be patented. So a lot of the patents that we see on maize varieties specifically are like pioneer hybrids, honestly. So we don't, to my knowledge, there haven't been too many examples of like indigenous varieties being like referenced in patent applications. Especially there was a series of court cases in 2010 and 11 that really said that, 12 and 13 maybe, that really said, like, drew the line, like you can't apply for patents on naturally occurring traits. And so if they've been around for that long, I think there would be a good argument to say that they just wouldn't be eligible in general.
That's wild. Thank you.
We have a question from Mason online. They say, how do seed growers avoid growing cultivars that will potentially someday become patentable by the breeder? Can a variety that has been released openly to the public by a breeder be patented after initially being commercialized without variety protection?
I missed the first part of your question.
Sorry. How do seed growers avoid growing cultivars that will potentially someday become patented by the breeder? So if a material is released and then.
Well, if the variety is out in the where the seed growers can get it and they grow it, then it really could not be patented because it's already prior use and not unique or novel. So.
Yeah.
Oh, sorry, I got it. So my question is about gene editing, and I know this probably falls within an example of naturally occurring phenomenon. But for example, if a company were to sequence a crop wild relative and identify a unique fatty acid profile and use that data to—
Excuse me, I'm sorry. Can you speak a little closer to the mic? We can't. Yeah, thank you.
Okay, is that better? Yeah, so my question was about gene editing and whether, for example, if a company sequenced a crop wild relative, identified a unique fatty acid profile that they would like to use to then edit into their crop, and then whether, I don't know what the landscape looks like right now. And so I'd appreciate any insights. Are people applying for utility patents on those types of things, or is that something that's coming down the pipeline, or what does that look like?
Well, I'm sure people are applying for gene edited products, but your specific example, it sounded like you were asking whether the fact that the fatty acid or whatever is already in the public domain. I don't think, and I'm not an expert on the molecular aspects, but I don't think the fact that it is already in the public domain would eliminate it as a possibility to be patented. I do think yeah, well, I actually question whether it should be at all in terms of the patent office, but I'm really not an expert on patenting gene edited products, but I don't think the fact that it came from teosinte, I don't think would make any difference, but I don't really know how they're patenting gene edited products these days.
Yeah, and I know there are some currently pending patent applications for gene edited varieties. I can't remember what the edited gene is specifically or where it came from. But I think that's certainly like an issue of concern for people, not just regarding utility patents, but also PVP. I know the sort of UPOP system has been in conversation about defining essentially derived varieties and really like getting clear on what the IP sort of rules around that is going to be.
Mhm.
And I know of at least one instance where a variety has, so the use of an accession from MPGS to derive a specific trait has been awarded a patent. So this is a case of downy mildew resistant cucumbers. They screened accessions in MPGS, found this trait, and then patented the method of using that accession to confer that trait in other varieties. So yeah,
the trait
it
could
is
not have
out
been,
there.
Patented itself.
But the
because-
trait couldn't, yeah, it's the method of using the accession to derive the trait that
Oh,
they
really?
got the patent for, yeah.
Thank you.
Yeah, just along those lines, I've worked with a gene called the shrunken-2I gene. And it was generated through mutagenesis. I did not do that, but then it was in the public sector for 40 years. And then at the University of Florida, they patented the use of that gene for improved germination. So it wasn't the gene itself, but the use of that gene, or how to use it, which is.
Great, thank you. We'll take the last two questions with Dylan and Miss Bonita.
Okay, thank you. Yeah, my question also relates, I think, to this topic of prior art and non-obviousness, but to use a specific example of some of the flurry of lettuce patents on like disease resistance. And if those disease resistances have existed in commercial trade and been sold by, private seed companies, but broadly described as foliar disease resistance or something like that. And then there's a patent on a specific gene, and maybe it's on how they're using the gene or whatever else it might be, but I don't understand how that wouldn't be, obvious to a trained plant breeder to take what was a non described or, not coded disease resistance and say, oh, we're gonna, see what exact gene is behind this. And why hasn't that been in prior art? And have there been any challenges that you're aware of to that type of patent usage?
Yeah, it's a great question. As far as I know, no, there haven't been any challenges, and I think that's part of the issue that, we're kind of circling around, is that really until these things like go into court and are decided, the patent holder really in some ways benefits from that lack of clarity, right? So as long as there isn't a decision regarding it, then they can continue to sort of make the claims as broad as possible. And it's really expensive to challenge a patent in court, and patent holders, of course, have like a lot of the largest patent holders have a considerable amount of market power and legal resources. But unfortunately, yeah, until it comes into court, I think we're kind of stuck with those open-ended questions.
So just to clarify, it sounds like maybe that would actually be deemed as obvious or non-enforceable, but it's just a lack of challenge.
Lack of money to challenge.
Yeah. Yeah.
I would say that I saw Jim Myers come into the room, and he's been involved in a number of those kind of situations. And I don't see him here, but he's at the meeting, and
Oh, there he is.
there he is. You want to say something about that, Jim? Because you have had direct experience about that.
So cue me in on the exact question here.
You
Dylan, you
phrase it better than
I don't think so.
I was asking about when there's patents on a specific gene for a disease resistance, for instance, that might actually have existed in commercial trade, but been only broadly described for lack of, maybe before people were sequencing what exactly was the allele for disease resistance, but then somebody comes along and patents that. Yeah.
Yeah, I can think of a patent on tomatoes where that happened, where they took a germplasm accession for late blight resistance and patented the use of that, similar to what was just mentioned. But I think the patent system is sometimes pretty vague about what exactly is being patented and what's the genetic control underlying it. The patents are granted on things that, they might be similar phenotypic traits, but then you can get to that same trait with different genes, and that's where it gets really muddy. There's a case in broccoli, right? Our broccoli that was patented for heat tolerance, primarily under California conditions, but there are other people who bred heat tolerant broccoli, and there's, it's unclear whether their material is covered by that particular patent. It's just a kind of, I don't know that I can add a lot of clarity. There's a lot of can of worms there.
Well, if you couldn't add any more clarity, then we're in trouble. We are in trouble, but that's,
Dylan, I also did want to just add one more thing that came to mind when you were talking about like lettuce specifically. There's also, I think, one incentive for companies to patent their material is to increase the value of their portfolio. And then also we know of companies that get patents so they can trade those patents with other companies who also get patents. So the purpose isn't actually to like enforce them against like seed growers they think are infringing, but rather like if one company has a patent on a specific disease resistance and they need access to this other company that has a patent on a disease resistance, then they sort of can see each other as equal trading partners and then can incorporate both of those into each other's varieties. So actually so Kat sent out some resources before this, and there's like a short module on IP, and there's a video from Adrian Shelton, who's a breeder for Enzazat, and like specifically talking about that. It's a good watch, I would recommend.
Thank you. And just thanks, Ms. Bonita. Just if we could we're running a little bit behind, shocker. So if you could keep your last responses a little bit briefer, we can continue to digest throughout the day, of course, but.
Yeah, because the question I'm getting ready to ask you is about my community of Black Indigenous farmers who've been keeping seeds in their family for hundreds of years, and they are afraid to death when they hear that Kenyan growers and Ghanaian growers are being jailed for 10 years for saving seeds and passing them on to their families. Also, we're hearing from young scholars. They're saying if we don't patent this particular mustard green or collard green, somebody else will steal that patent with us. So please, as you begin this whole thing, let's talk about what this means for everyday people who basically brought us the food that we eat today, the people of the global South.
Yeah, thanks so much, Bonita. Yeah.
yeah, I guess it's a concern among many people. And later on, we're going to talk about defensive patents or defensive information, where you make a record of that's been in your family for however long period of time, forever. And you make a record and talk about it. And the downside with that, I mean, and I don't think I think that's what people should do is publicize what they've got. The problem is then that also makes them more likely that somebody's going to come and take some stuff. But if they actually have it, if it's clear that it's in the public domain, they should not be able to patent it. But if it's in the public domain, then people can take it and use it for something else.
Thank you, Paulina and Bill and everybody who is joining us online. Appreciate it. Sorry we didn't get to as many questions online. And thanks for all the questions in the room. I'm going to pass it back over to